We are live. Welcome to Crypto Law TV. I'm John Deaton, the founder and your host today. We are on status quo, which means we're waiting on the Ripple decision. We're waiting on other pleadings. We're waiting on the library judge to render his penalty phase decision. So that's where we are in the grand scheme of life in the war against crypto. What we're going to do today, we got a lot of stuff to get through. I'm going to get through it as fast as I can, but we unsealed the Hinman deposition. And when you unseal the Hinman deposition, you learn something. First, the timeline that I and my friends put together, because I needed their help, that timeline that has 7 million views on Twitter has been 100% validated. Now, we're going to talk about this ETH gate and the only game in town and what went down. But before we do that, we have to back up. Let's back up to put things in perspective, because I've heard Joe Lubin and I've heard other people say, oh, ETH's ICO, it was not an illegal securities offering. Bill Hinman never said it was. There's multiple times when he said that. So I want to first put that in perspective, and then we're going to speed through a lot of evidence, a lot of things. Stay tuned. It's going to be for fun. So let's kick off with someone that I've spoken to. Seems like a decent guy as far as dealing with me. I know he's had some issues. The government dismissed the case against him, but he called himself the Ethereum ICO architect. That's attorney Stephen Nayeroff. And let's see what he had to say after the ICO a couple years later.
But he said to me, he said, the problem is our lawyers are telling us this is an illegal securities offering. Which in fact,
and then after he said that, he said, and it was. And everybody concedes that. Now, Mr. Lubin says, oh, no, it wasn't, as I said. But let's talk about what his thoughts were before that free pass was given. So let's look and see what Mr. Lubin said. He wrote that he believed at one point in time he may get arrested and tackled on the tarmac of JFK. Okay, that's a direct quote from Mr. Lubin. Now, it wasn't just him, but there was another co-founder called Chetrit. Look what he said. There was a real possibility they would end up in jail, and he left the project because of that. But anyway, so that's the ICO in perspective. Now, we know that Vitalik and the Ethereum co-founders went forward. They did their ICO, first 2,000 ETH for every Bitcoin, and then it got reduced. And when it comes down to it, the ETH ICO came out to be about 30 cents, basically 31 cents. I think we have it right there. That's what the ICO was. Now, we don't know who bought the ICO, right? We have the disguised whales. We have the video on crypto law. .us, which talks about how you have, if you want to put $3 million or several $1 million in the ETH ICO, there could be multiple email addresses, and so that you could quote unquote disguise who in fact did it. So we never have found out how much ETH Mr. Lubin and other founders, co-founders bought, but there was an article in Cointelegraph, and Cointelegraph said that there was basically reports that Lubin and another co-founder could have purchased or funded 95% of the Ethereum ICO that raised ultimately $18 million. Okay, so that's the ICO in perspective. Now let's fast forward, because that ICO was 2014. Let's fast forward 3 years where a guy named Jay Clayton was appointed to be SEC chair, and let's see what he had to say about. He was conflicted, right? Rolling Stone called Jay Clayton the most conflicted SEC chairman in the history of the SEC. But let's go to the hearing.
A strategic company that wanted to try to avoid an SEC enforcement action could simply hire Sullivan and Cromwell to represent them before the agency, and then you couldn't vote for enforcement against that company. Is that right, Mr. Clayton?
I'm not sure about that, Senator.
Well, you do know the rule that if they are represented by Sullivan and Cromwell in front of the agency, then you're going to be banned from being able to vote against them.
If they are represented by Sullivan and Cromwell in front of the agency, I would not be able to participate.
That was my point.
Now, it sickened me to actually play anything with Elizabeth Warren, but that is in fact a point. And we've got to get a point in our country where a decision of who you hire as a lawyer doesn't dictate your regulatory path. We've got to do something about that. Do you realize how sad it is? I've said before, if I'm Stuart Alderodi and I'm the general counsel of Ripple, I'm going to scratch my head and say, damn, I wish when Chairman Clayton got appointed, I should have just hired Sullivan and Cromwell to do some shit for Ripple, do some legal fees, do something, because that would have caused Clayton from voting to enforce an enforcement action against Ripple. And Fox Business reported it was a 3-2 vote, right, with Clayton going with the Democrats against Elad Roisman and Hester Pierce. I didn't say that. That was reported by Fox Business. So just imagine if that had been done, there would be no case pending, at least on Jay Clayton's watch as he's walking out the door. On May 4th, 2017, Jay Clayton was confirmed as the SEC chair. And maybe Joe Lubin was watching that hearing, or maybe Joe Lubin's just a smart guy. I think we have to concede he's a smart guy. Because he did the smartest thing, and no one can blame him for this. Let me be blunt. I hold certain things about Lubin and how he's targeted XRP and things of that nature. I think he took the regulatory pass. He could have taken it with more grace and all that, but no one can fault the man for being smart and then hiring Sullivan and Cromwell, because that's what he did. Within 60 days of SEC Chairman Clayton's confirmation, Joe Lubin, on consensus, hired a lawyer, Patrick, let me get his name right, Patrick Baraducci, to be his deputy general counsel at consensus, hired several other lawyers who were partners from Sullivan and Cromwell, but then also hired Sullivan and Cromwell to represent consensus itself. All right. And we know that consensus, you're going to learn later, brokered the deal with Quorum and JP Morgan. But the bottom line was it was a brilliant tactical move by Joe Lubin, because he played the game that Elizabeth Warren was talking about that could be played. Okay. And he basically stopped Clayton from voting an enforcement action that would be against the interest of Clayton's law firm's big client consensus. So he hires them. Now, the thing to know, Sullivan Cromwell is hired for consensus, which is facilitating the enterprise Ethereum alliance. Okay. And growing that. That's part of the representation. And so that's how it begins. November 30th of 2017, Joe Lubin announces and consensus announced the Brooklyn Project. And guess who is picked to be co-director of the Brooklyn Project? Yes, the deputy general counsel that was hired from Sullivan Cromwell. So basically one of Jay Clayton's partners was hired to be co-director and deputy general counsel. So what's that lead to? Now, some would argue that gets you access, right? Because now the law firm, remember, Jay Clayton still did work after the SEC for Sullivan and Cromwell. All right. He led an entire division. What it arguably gives you is access to the regulator. And that's, in fact, what happened, because on December 13th, 2017, Bill Hinman met with Joe Lubin and consensus at the SEC. That was in the timeline I put out, and that's been confirmed in the deposition. Now let's go to page 41 of the deposition. You'll see there at the bottom, the Ripple lawyers ask, are you familiar with something known as Enterprise Ethereum Alliance? Go to page 42. And that's when Mr. Hinman goes, I'm not exactly sure, blah, blah, blah. And then he says, do you understand in the middle that Simpson Thacher is a participant in the Enterprise Ethereum Alliance? Hinman answers, I understand that the firm is a member. He's asked, do you know when Simpson Thacher first became a member? And he says he's not sure. Okay, now take that for what you want. All right, so you can see the Ripple lawyers are going somewhere where we've all known there is ripe for cross-examination. Now, if you go to page 152, you will see that they didn't black out consensus at the top. And obviously we can all tell basically whose name has been blocked out. He's asked, and you knew that arguably Joe Lubin was found, or consensus was founded by Joe Lubin, correct? You know, again, you can say I'm speculating, but that's what we believe is most likely the case. And then it goes on and he talks about the founder. I'm not sure consensus's relationship with the Ethereum Foundation, all of those things, right? And then we get to page 155. No, go to 154, where they ask him about, are you aware that Joe Lubin is also the co-founder of Ethereum? They ask him, are you aware that it's been reports at the bottom that Mr. Lubin is worth over $1 billion? All right. Now, on page 155, this is interesting because the lawyer in the middle of Ripple says you had numerous occasions to talk to Consensus and Lubin. And you see the answer. Well, I'm not sure I would agree with numerous. And then you go down one more question, and what does it say? I would say probably 4 to 5 meetings. Okay, that's access, people. 4 to 5 meetings between that December 13th meeting and June 8th, 2018, just 1 week before the infamous speech. Okay, finally, I want to turn to page 157. And you see it's interesting here. In the middle of the page, it's asked, did you have any communications with Chairman Clayton about any of your communications with anyone affiliated with Consensus? And his answer is yes. How many times? Once or twice. So let's just ask ourselves, why is the chairman asking about follow-ups on these meetings that Bill Hinman is having with Consensus and Joe Lubin? It's because his firm is their client, and he's making sure he did his firm a solid, or whatever you want to say. The bottom line is you can't argue that that is extraordinary amount of access to the regulator. Okay, now the depo goes on. I'm not going to show all the pages, but it goes on to talk about, they wanted to find out about basically emails between SEC and Consensus and Lubin. Those are the same emails that Empower Oversight, an independent entity that has nothing to do with the XRP army, has nothing to do with crypto, said, we want to see those emails. We want to make sure that there's ethical governing in our government. And the SEC refuses to turn over those documents. Okay, let's go to page 165. And that's where you could see the Ripple lawyers at the bottom are talking about Sullivan and Cromwell and the representation, and that he knew that they were representing Consensus. One thing it's hard for me to believe in all these meetings, right? These preliminary meetings, that December 13th meeting, if you go to page 168, Bill Hinman is asked whether or not ETH came up. It's asked, did anyone from Consensus at the meeting ask you or any member of the Division of Corporate Finance to make a determination that Ether was not a security? No. Did the topic come up at that meeting? No. Now, that's interesting to me because Bill Hinman in this deposition claims that this discussion was about some ECR20 token that they were promoting or wanting to promote. And in fact, if it's an ECR20 token on the Ethereum blockchain, you're telling me that Ether didn't come up at all? No. Is it possible? Sure. But when you read this deposition and you determine Mr. Hinman's credibility, it's going to make you question it more. So that's the meeting on December 13th, 2017. The very next day, Matt Corva, who is the general counsel of Consensus, publicly states that they're building an alliance with regulators, right? I don't blame them for saying that. They had just met the night before. And he's saying, hey, we're working with regulators. We're trying to get clarity. No one can blame them for that. Okay, I don't care what your position is. At that point in time, Brad Garlinghouse wanted clarity. ETH people wanted clarity. The whole damn market wanted clarity. All right. Now, We fast forward to January, the next month, January 25th, Jay Clayton, this is 2018, Jay Clayton gives a speech. And in this speech is Chris Dixon from A16Z and others. Jay Clayton walks over to Mr. Dixon and says to him, because they're wanting clarity, right? Says, I tell you what, Chris, get together a small working group and put together a memo and send it to Bill Hinman. And, we'll consider what you have to say. Now, I got blocked by Chris Dixon because all I did was simply tell you what I just said. And I also said, apparently Ripple wasn't invited to that small working group of people, of venture capitalists. That was A16Z. Okay. Now, what does Chris Dixon at A16Z do? Well, he's going to call a lawyer that has been A16Z's lawyer from day one in crypto, an attorney called Lowell Ness from Perkins Coie. By the way, Perkins Coie is a member of the Enterprise Ethereum Alliance. Sullivan Cromwell is representing consensus and promoting the Enterprise Ethereum Alliance. Okay, now that's Lowell Ness. So what does Lowell Ness do? He starts writing that memo. And he meets with a couple other attorneys and law firms. And by this time, we're in the beginning of 2018. And this is when Brad Garlinghouse is out there publicly talking about how Ripple and XRP is going to replace SWIFT. So XRP starting to gain momentum. They're talking about ODL, et cetera, et cetera. Let's go to March 26th. And there is the Perkins Coie memo. So those lawyers, that working group, did exactly what Jay Clayton told them to do. And you see it's directed there to William Hinman and Valerie S. and Amy Starr. And it's written by Lowell Ness. 2 days later, after this memo is sent, Bill Hinman meets with these venture capitalists that wrote the memo. And they bring with him this lengthy memo, but they also send him a safe harbor proposal. And of course, because Sullivan Cromwell represents consensus and Perkins Coie is a member of the Enterprise Ethereum Alliance, if you look at the membership, what it says is the promotion of exclusively enterprise solutions on the Ethereum blockchain. So it should not surprise you that the only token listed in the safe harbor is Ethereum. Okay. And so that March 28th meeting, they go in, they ask for the pass, they ask for all these things, right? And that was the mention of Ethereum you saw there. Well, Lowell Ness is at this meeting along with A16Z folks. And I already told you that Lowell Ness was the A16 attorney from the beginning. How do I know that? Because he said it. We have video clips. I can't show you them all today, but we have video clips of him. Let's go to page 179 of the deposition. So this guy sends a memo to Clayton. To Hinman. He meets with Hinman 2 days after it. So of course, he's asked at the bottom of that page, Hinman is asked, do you know someone named Lowell Ness? And what from Perkins Coie? What is Hinman's answer? It's ringing a faint bell, but don't really. I think he meant not really, doesn't really ring a bell. I couldn't pick him out of a crowd. I don't know if that hurts Mr. Ness's feelings, but it's interesting because Lowell Ness has a different response. In fact, let's hear what Lowell Ness said.
My playbook these days, in fact, honestly, ever since I sat across from Bill Hinman and he sort of said, we're going to accept your proposal to give some guidance here. I stopped giving guidance. I said, let's be consistent with the SEC's hand wave approach here, because that's who matters. When you get into court, like the court's going to give deference to the regulator. Nobody wants to, I get that. I really do. And my heart is in it. I love the academic arguments about whether or not something should be a security. But I just think, honestly, to be pragmatic here, you should just treat it like security and be done with it and move on, because we all know how to do that. And so that's, to me, the path of least resistance right now until case law changes.
Now, Mr. Ness is right, that the regulator gets a lot of deference. The regulator has a lot of power. Look at the power that's been exerted. Robinhood delisting things, other places delisting things. XRP got delisted, by Kraken and Coinbase and crypto.com, all because a regulator called it a security. And so they have a lot of power. And that's why gaining access to them is so important. But clearly you could see Mr. Ness saying, as I said, across the table. And remember, that's not the only meeting that he was there with Mr. Hinman, who couldn't pick him out of a crowd. Now, let's go to page 180 of the deposition. And you go to 180 of the deposition, and you'll see that on April 12th, Bill Hinman sent an email right there. That appears to be an email you wrote to, and you can guess who the person is at Consensus that he wrote to. And you see that there. Right now, let's go to, so they had this meeting, and there was an article written where these venture capitalists went in trying to get clarity, trying to get a free pass, closed door meetings with the SEC. Well, guess what? I think it was the New York Times. I'm not sure, but Nathaniel Popper leaked the meeting, and he wrote an article talking about how these Ethereum investors went in to have this meeting to get basically a regulatory free pass. And it became the worst kept secret that one could imagine, because coincidentally, there's this fella at MIT who is talking about blockchain. His name's Gary Gensler, who would come on to be the chairman of the SEC. He even talked about this secret meeting. Check it out.
And a security token transformed to be something else. And a group of venture capitalists went into the SEC 10 days ago. They've circulated paperwork to a lot of people. And they're sort of saying, believe us, we get you. We're with you, SEC, but we have a bunch of clients that are going to evolve to be a consumable token. I kind of don't think this is going to work. I don't think there's any precedent in the law for a security to transform to be something else. But this is an issue on the table, and it's a worthy debate.
And here we are, right? The whole process, whether or not secondary sales, which my position on our securities, can something transform? And the answer, of course, is yes, because a token doesn't transform to anything. It's still a digital code, right? Beaver can be packaged, because it was, as an illegal security. Bitcoin was packaged as an illegal security. Still Bitcoin, still Beaver, still Orange Groves, still XRP. But that is the huge debate that's going on today. But isn't it interesting that Mr. Gensler said, I don't think it's going to work. So we have to ask ourselves, why did it work? Well, we already know about the meeting on December between Consensus and Bill Hinman. Well, there's another meeting on April 23rd, 2018, where Hinman meets again with Consensus and Mr. Lubin and everyone else. And so if you go to page 181, or it's 182, thank you. If you go to page 182, you'll see that it says that he's happy to get a call that says, I can loop in members from our internal legal team who have been in discussions with you and your colleagues. That's that Sullivan and Cromwell legal team that Mr. Lubin put together. And then it goes on. You can see at the bottom, the meeting was to learn about Ethereum's support network. Okay, now let's go to page 185. All right, page 185, you can see that down at the bottom where you have the two blocks there, it basically says the Ripple lawyers asked, did members of your staff ask Mr. Lubin directly or indirectly how many units of Ethereum he owned? And then you get into the answer. I think we would have asked that. I go to page after 185. It goes on where he basically says, we had to ask it. I know that we did ask it. And then the Ripple lawyer said, well, what was the amount? And he goes, I don't remember. And then they go on, they talk about the Ethereum Foundation. They were asked, how many tokens did the Ethereum Foundation have? And Mr. Hinman said, we asked those questions. We knew, but we didn't find out. All right. And that was on page 188, where you see the Ethereum Foundation questions being asked. I'm not going to go through the entire depo for time, but after this, there are several discussions where the Ripple lawyers bring up the fact that 50%, over 50% of the Ethereum mining and voting was centralized with 3 entities, basically. And he asked, were you aware of that? And he's cross-examined on those things. And he concedes that it's relevant to his speech, but he can't remember any of the specifics or any of the details of it. You go to page 193, and you'll see that the Ripple lawyers in the middle there said they want to know about this due diligence that you were doing to make sure that it was sufficiently decentralized, whatever that means. And of course, Mr. Hinman says there was no central file maintained where we could find out exactly who was asked what, who was interviewed, and what those due diligence findings found. We go to page 194, and at the bottom of 93, it asked whether or not, did you tell anyone between April 12th and June 14th you were planning to give a speech? And at the top of 194, he answers the question, no. Now, some find that hard to believe, and I'll let you determine it yourself as we learn more information and I share with you. Then it basically asked, in the middle of 194, did Chairman Clayton suggest that you reach out to Mr. Lubin prior to your April 12th, 2018? And then there is an objection. And then, of course, you see the name Andreessen Horowitz at the bottom. Let's move on to 196. I find this interesting. Now, remember that Bill Hinman today is a partner with Andreessen Horowitz. Go to the middle of 196, please. And it says, basically, who did you talk to? A fellow by the name of Scott Kupor, K-U-P-O-R. That's someone who is a partner. I might be the managing partner, for all I know, of A16Z, or was. And then they bring up the safe harbor. But look at the answer that Hinman says. He goes on to talk about one thing that I'd like to clear up a little bit. When folks come in and ask for consultations like that with the staff, we usually tell them that we expect it to be confidential, both on their part and our part. So I don't know if it's appropriate for me to answer that in light of that, but I'll look to direction from counsel talking about the SEC's attorney. And then he goes on to say the depot will be designated confidential, so you can feel free to share that. But I found that very interesting that there he was before a partner at A16, kind of protecting the communications that A16 was given to the SEC. Again, these are emails that Empower Oversight is litigating to get that the SEC refuses to give up. And then it just goes on. And as you go to 197 at the top, it's talking about how Mr. Kupor came in with a group of folks from Perkins Coie, Andreessen Horowitz, et cetera, et cetera. And again, that safe harbor only mentions Ethereum. Okay. Now, if you go to 200, you'll see that the memo, the Perkins Coie memo, is being asked questions at the top. I'd like to direct your attention to the second full paragraph. Basically, we're looking at that memo right now. Why is that important? Because the Perkins Coie memo is the basis for the speech. The Andreessen Horowitz ETH investors wrote, who all belong to the Enterprise Ethereum Alliance, wrote a memo and a safe harbor for ETH. All right. They're seeking regulatory clarity in an uncertain time. On its face, no one can blame them for that. Again, certain entities in the other ecosystem of crypto weren't invited to the party, though, if you know what I'm talking about. And so Lowell Ness, if you go, Digital Asset Investor had found this one, and it's on the Crypto Law site, talks about how the speech tracked his memo very well. And last time I told you there were words like irrational exuberance that were contained in the first version of the draft. So that Perkins Coie memo is in fact the impetus for that speech. And then we in May now, before the speech, it's May 10th, 2018. That's when Charlie Gasparino talks about the Brooklyn Project and how they are seeking SEC sanctioned self-regulatory body. And there was the Brooklyn Project said, no, that's not exactly what we meant. And Charlie Gasparino hit him back and said, I know exactly what you said. And he even talked about it on Liz Clayton. But what I want to show you right now is that was May 10th when Charlie Gasparino kind of broke that story. Well, 2 days later, Joe Lubin gives a little bit of a talk about the progress, where he's making strides with regulators, if we have that.
There are many other cryptocurrencies. We never positioned Ether as a cryptocurrency. We called it a crypto fuel, one of the first crypto commodities. And we need financial mechanisms to make this all work. We need mechanisms to enable people providing their resources to hedge. We need mechanisms to enable tokenization of securities, utility tokens that wouldn't be considered securities. And despite the fear, uncertainty, and doubt that you've heard over these many months, we're making great strides in helping the people that make those decisions understand that there is great value in utility or consumer tokens, despite the fear, uncertainty.
Right. So great strides with the regulators. So let's now, okay, now that's 1 month before the Hinman speech. Okay, let's go to page 221 of the Hinman deposition. And you will see there that Valerie S. sends an email, and the subject line of the email is Buterin, listen to my panel. And then says he came up to me right after the panel and said he really appreciated my remarks and would like to talk to us at some point. Okay, that's Vitalik. Can't blame Vitalik for wanting clarity. You know, let me state that up front. And then Bill Hinman's response is basically, that's terrific. Let's talk about, let's get Vitalik in here. And then Hinman wrote, quote, that the consensus folks are very happy we are talking with him as well. And that's when the Ripple lawyers start asking, how do you know how happy the people at consensus are, and so on and so on. If you go to page 222, you will see that a call was arranged through Joe Lubin for Vitalik. And you get into how happy that Mr. Lubin is that they're finally getting to talk to Vitalik himself. Go to page 223, and that's when you get into there was a previous call. They were happy to hear we'd be talking to Buterin, and they just start talking about the arrangements. Now we know from the Hinman emails, okay, because this is all on May 12th. All right. May 16th, 2018. We know that Hinman in the emails that were unsealed said, I'm speaking to Vitalik later in the week to confirm, and learn more about the Ethereum network, etc. So then you have basically, if you go to cryptolaw.us, I can't play them all. There's a video of Mr. Lubin literally talking before the speech about things that are contained in that Perkins Coie memo and in the Hinman speech. Who is the best friend of Joe Lubin? It's Mike Novogratz. And June 5th, 2018, right? Basically, what's that? 9 days before the Hinman speech, Mr. Novogratz became clairvoyant, because listen to what he had to say.
There are bigger decisions to make. Bitcoin they've already kind of said it's not a security, okay? But Ethereum, they haven't ruled on yet. I bet dimes to donuts. They will say Ethereum probably was a security, but it's not anymore. And they're stuck because they weren't ahead. There is this group of tokens that were issued, probably 2,500 in total, but in reality, probably 200 that matter, that are in this kind of regulatory no man's land. And they got to figure out how to deal with that. And they're working on that right now. My gut feeling is they're going to take out a law firm, they're going to take out a token, they're going to take out some of the promoters of these things, just to say, dudes, you got to play by the rules. But when we're talking to them about going forward in the future, they're very constructive at wanting to to see this new innovative way of financing companies, of bringing liquidity and access to markets to the general population that they never had?
Well, he said access to markets. I think this proves that access to regulators is actually more important, fortunately, in this day and age. Now, listen, Mike is a smart guy. There's no doubt. I mean, despite the lunatic, he's a smart guy. But to be that specific, and also there's videos of him talk about he gets all his information from his college roommate, Joe Lubin. So let's just all call it like it is. Certain people had knowledge that this speech was going down. Okay. And so what else happens? A couple days later, on June 8th, there is a meeting with Vitalik. Let's go to 224. And then it says it's a telephone call with the Ethereum Foundation. And then let's go to 226. On 226, in the middle of the page, Hinman says, the only folks I specifically remember on the list would be Vitalik and Tom Kim. Now, who's Tom Kim? Isn't this interesting? As it turns out, if you go to page 227, we find out, and that is that Mr. Kim basically used to be special counsel for the Division of Corporation and Finance. So that's who's working with the Ethereum Foundation. And interesting in this is that Mr. Hinman sent 7 questions that he wanted answered, or areas of topic that he needed addressed. And Mr. Kim, who's special counsel, who used to be the guy who advised a guy like Bill Hinman at the SEC, made it clear that they would only answer those questions. I found that very interesting. When you're seeking regulatory clarity, you're like, listen, we'll answer your questions, but only these, because we're not prepared. We haven't vetted all the other answers. And so, you know, it's some insight into what goes on there. Now, the same day as that meeting, Joe Lubin does a video. It's on the Crypto Law site, where he says that he predicts the SEC is going to start coming after projects. He's going to start scaring projects out there. 1 week later, it's June 14th, 2018. We get the speech, and Mr. Lubin appears on stage right after Bill Hinman, and ETH wasn't the only topic. Let's see if we play that.
All right, speaking of, Ripple.
Ripple?
Overvalued or undervalued?
Oh, I don't want to say anything mean about them.
You don't have to.
Massively overvalued.
Okay, you heard it here, right? Okay.
Okay, I misspoke. That was June 26, 2018. But if you go to cryptolaw.us's site, you'll see the day of June 14th Hinman's speech. Right after Hinman gives his speech, Joe Lubin gets on stage, and the moderator, Joe Lubin, says, did he mention XRP, by the way? Did he mention XRP? And the moderator says, no, XRP wasn't mentioned, only Bitcoin and ETH. And Mr. Lubin goes, that's very interesting, isn't it? Always seemed to have XRP on his brain, as you saw from his comment being massively overvalued. I have to note that the next day, Mr. Garlinghouse for Ripple was asked the same question about ETH, and basically said he thought ETH was undervalued. He took the high road. Now, take that for what it's worth. I do want to play now an August 19th video from Hinman. Listen what he had to say. Where he praised
Hinman's comments, but more broadly, do you feel like we're kind of at a place now where we're on the verge of getting some important clarity and regulations in the United States?
I think we've got a lot of pretty high quality clarity, in my opinion. The SEC has been very clear that, I guess Commissioner Clayton indicated that they wouldn't grandfather anybody, that big surprise, they're going to enforce securities law roughly like they have for many decades. And there will be lots of projects that sold securities, unregistered securities, to Americans that have received communications or will receive communications. My thesis is that the SEC doesn't want to kill blockchain for America, and so they have to be very careful sort of have to thread the messaging needle where they present some positive statements about Bitcoin, about Ethereum, about consumer utility tokens. So I think we're still in that phase where the SEC is communicating that we understand this is something new and it's going to be an incredibly valuable technology, but we also have rules, and all the projects out there need to pay attention to rules that are in place to preserve the sanctity of markets and consumer safety. So I'm pretty comfortable in this country and in various countries around the world that the securities law issues are pretty close to resolved. And I do think that there are going to be some bad times for some projects going forward, but I think that's going to be a very good thing. Getting clarity with respect to regulation is going to really kickstart or re-kickstart the token.
On August 19th, 2018, Mr. Lubin said that crypto regulations were pretty much resolved. And here we are today. How about that? It's funny that at the same time that Mr. Lubin was going around praising the SEC for such great high quality regulatory clarity, Hester Peirce, who actually is a commissioner, was giving speeches and statements to the contrary, saying how they needed to provide clarity. There's a video after this, we're not going to show it, where Lubin goes on to talk about there's a reckoning coming for all these other illegal projects. On October 15th of 2018, there's a video of a statement of Joe Lubin where he talks about how Ethereum escaped being a security or classified as a security because, quote, he created a reality with words. That's where you get into the crypto fuel kind of stuff that they were talking about. But let me play you the January 19th, 2019 video where Hinman is cited as a source of Mr. Lubin.
So we are big friends and fans of that organization. I think they're really understanding the space well. They are applying this thing called securities law to business in America and other places, as they have done for many decades successfully. They're identifying fraudulent projects. They're identifying obvious transgressions of securities law, but they haven't had a heavy touch, really. They've been gathering information. They've been taking some actions. They've been very clear that they understand there is this new construct, this protocol-based open platform.
So you think they get it?
Yeah, we believe they get it. They've introduced a new construct, decentralization, into their thinking. So in addition to the Howey test, they have this new construct that they're seeing certain things in. So they consider the Bitcoin network and token and issuance mechanisms. They consider the Ethereum network token and issuance mechanisms to be decentralized, and therefore no transactions involving those particular assets are considered to be transactions of securities. They have not said the same thing about other tokens, the Ripple token, for instance, and they were clear that they were going to come out with statements to sort of assess these different tokens, and I believe they've made all the statements about decentralization that they're going to make. And so,
wow. They've made all the statements that they're going to make, and he's citing Bill Hinman as his source. You know, what's crazy is, did you hear what he said? In addition to the Howey case, the Howey test, they've introduced a new construct. That's not how the law works, people. There's nothing in addition to the Howey test. It's the Howey test. It's the only test. You meet all and satisfy all factors of the Howey test, and you're an investment contract. If you do not satisfy all factors of the Howey test, you are not an investment contract. There is no, pass Howey, don't pass Howey, but you're not sufficiently decentralized. It's bullshit. It's not the way the law works. But you notice how he says there's no more statements. It's just ETH and Bitcoin. That's the only ones that are going to get clarity. Okay. Now, for those out there that say, well, Lowell Ness, maybe he was exaggerating because he wrote the speech and he's giving himself props. Well, there was another lawyer, part of that working group, called Nancy Wotas, and she said, in her words, that most of the speech was lifted from the memo that the ETH investors and A16Z put together. Now, interesting, since she was there in the meetings with Bill Hinman, let's listen to what Nancy Wotas and Wendy Moore, who's from Perkins Coie, had to say about it.
What's interesting is I don't think Ether is decentralized. I think it's fully functional, but I don't think it's decentralized. But the chairman, the division director said it's decentralized. So, hey, look at the metrics for Ether. And hey, you do a little better than that, hey.
Then why isn't Ripple?
Yeah, and I wonder if they would have said that 3 years back. I mean, now they came back and said Ether is not, it's not a security, but, it's now. How about 3 years back? Would they have the same answer?
There's no question. Ethereum violated the law in the SEC's view when it issued its tokens. He said that in the speech, even though consensus says, oh, no, that's not what he said. That's what he said. But then he said, look, the securities laws really, it doesn't add anything now because Ether is decentralized. Again, no. Yeah, exactly. So it's a long process.
Now, did you pick up on that? Why isn't Ripple? If ETH is sufficiently decentralized, then why isn't Ripple? We don't have to get into which one's more decentralized or how many nodes or this or that. The point being is those were people in the room with Hinman who disagreed with Hinman, who was part of trying to get the agreement from Hinman, which always goes to why did Hinman push this speech so much? Why did he go against the Office of General Counsel's recommendation to take it out? Why? I think we know the answer. All right. Now, what I said about Mr. Lubin getting regulatory clarity, and the whole point of this was the ETH is the only game in town. Those aren't my words, people. Let's find out who coined that phrase. ETH is the only game in town.
Essentially online interest-bearing savings accounts for derivatives, for equity, for bonds, for synthetic financial instruments. May have said insurance already, but the prediction market. So all of these elements are realized as protocols, as essentially Lego building block protocols that can be plugged into one another. And pretty much all of them are being developed on Ethereum 1. The reason they're being developed on Ethereum 1 is because if you're going to build applications that hold a tremendous amount of value, you need a very secure foundation. And there are really only two decentralized protocols on the planet right now that are sufficiently secure enough and decentralized enough so that they can be trusted. Those are Bitcoin and Ethereum. And it's very difficult to program on Bitcoin compared to Ethereum. As a result, all of the early developers started building on Ethereum. And once you have all the developers building on Ethereum and all the liquidity in terms of the different value tokens on Ethereum, then it pretty much becomes the only game in town. There's no reason to build a DeFi protocol on some other platform, A, because it's not going to be secure enough, and B, because just nobody's there to do the trading. So even other protocols are building bridges to Ethereum, other protocols like Bitcoin, so that they can participate in this new decentralized financial plumbing layer for the planet.
Now, there's another reason. Now, just in our timeline, because I'm going to wrap up here, just know that was August, right? August 2020, Consensus buys Quorum and the JP Morgan coin, and Sullivan and Cromwell brokers that deal and gets a part of Consensus. Okay, so understand that takes place. Then that's August of 2020. And then one of my final videos is October 6, 2020, where Joe Lubin talks about another reason why really Ethereum is the only game in town.
Ethereum's early advantage is apparent in so many ways. One is a regulatory advantage in that Ethereum and Bitcoin arrived on the scene before regulators were watching. And so via different mechanisms, we were able to distribute our tokens broadly and equitably, which is critically important for the success of decentralized protocols like this. If you're a great team right now with a great technology, you need, and you have designs on being a layer one protocol, you really need massive decentralization to claim that you're a layer one protocol, to claim that you're a new trust foundation. Otherwise, you're kind of a pretty small platform and potentially corruptible. And so we were fortunate enough to be able to frame our token as a utility token and get the excitement of the community of developers, entrepreneurs, users. A project right now, even if it's excellent, needs to incentivize its community to be excited about the token. And usually the way to do that is to say, hey, this token is going to appreciate by the agency of this group over here. By definition, that's a security. This is Matteo Leibowitz's distribution quadrilemma. It's not my construct. And so regulators are watching. So pretty much all the tokens need to be either introduced into the world in a convoluted fashion or are really just going to be seen as securities so that they can't be distributed broadly and equitably. They are being called VC coins. Oh, sorry, Jamie, or professor coins, and
or worse names than that as well.
So, what's he talking about? He's talking about a regulatory advantage. It's called regulatory capture, and it's when a group of small investors capture the regulator and they get beneficial, they get a free pass for what they want to do, and they get such a head start because no one wants to say, okay, we got a $10 million budget, we need to put $3.5 million for compliance and dealing with the SEC and hiring a whole bunch of lawyers to work through it. It's just not how it works. So Joe's saying what happens? You go to the one that has clarity, the only game in town, so to speak. So he goes on to talk about how all other tokens are, quote, spectacularly disadvantaged compared to Ethereum. What else happens in October of 2020? One River comes out and makes a $1 billion bet on two tokens, the two that only got clarity, Bitcoin and Ethereum. And then in our timeline on December 17th, a letter from Joe Grunfest goes to all of the commissioners to Clayton saying, Jay Clayton, as you're walking out the door, do not drop this massive lawsuit. Talks about how a massive exodus of everyone who pushed the lawsuit is leaving, and that raises obvious concerns. He talks about how it's traded, XRP's traded for 7.5 years. There's no exigency for you to do this. Don't hurt all these innocent people by filing this case. There's no reason to do it. And you're treating ETH differently, and you shouldn't. And Joe Grunfest is the best person to speak out because he helped Ethereum. Remember that first video I showed you of Attorney Neroff talking about? He talked with, guess who? Joe Grunfest. He acted as the liaison. He doesn't have a dog in the fight, people. And he's saying to them, don't do this. Joe Grunfest said, if you file this case, it will cause more damage in a non-fraud case than any case in the history of the SEC. And it happened. Interestingly, just the day before Jay Clayton left the SEC forever, he met with someone on December 21st, 2020 by the name of Gary Gensler, who would go on to be the SEC chair. Do you think the lawsuit was raised? Do you think Jay Clayton is going to drop the most significant SEC enforcement action, non-fraud enforcement action in modern history without giving the new chairman a heads up? Of course, they had to talk about it. And so do we have those notes? Of course not. Are they going to be protected? Of course they are. The next day, the lawsuit is dropped. Fox Business said it's 3-2. I don't know that. I'm just reporting what was reported. And so I want you to keep in mind as you listen to this timeline that the SEC has fought in power, oversight, lied, actually in court until they were called and sued. You have Sullivan and Cromwell representing Consensus and Enterprise Ethereum Alliance. Clayton was there. Perkins Coie, a member of the Enterprise Ethereum Alliance. Simpson Thatcher, Hinman's firm, a member of the Enterprise Ethereum Alliance. Hinman is an ongoing profit-sharing partner. I'm not going to do it today, but you've seen the emails. He was told, do not talk to your partners. If you do, you violate the criminal financial conflict laws of the United States, Bill. We've told you this already, Bill. We don't have to talk to you and meet you live and send any more emails, Bill, because it doesn't change. You're an ongoing profit-sharing partner. Stop it. And he didn't stop it. We know that for a fact. And so Clayton voted not, remember that first hearing with Elizabeth Warren, where he said, I would be recused if I was to vote against an SEC enforcement action of one of my firm's clients? He didn't. He only voted for his law firm's clients to sue the number one competitor. And when Joe Lubin says XRP was never considered competition, why you talk about it so much, dude? Like every time you interviewed, you're bringing up XRP. We saw the videos, and I didn't show all of them. I just showed a couple of them. And so the last thing I'll end with, I want to end with page 135 of the deposition, where Bill Hinman is asked, you got to remember, people, this was 15 months before the Hinman emails were released. So the Ripple lawyers had asked all kinds of questions about that speech, and Hinman wasn't answering them because he was instructed not to because of deliberative process privilege, attorney-client privilege. They didn't have the foresight to know that there would be 7 rulings about it and that eventually we would get those emails. And those emails show something very different. Shows that he's meeting the deposition. He's meeting with Consensus. He's meeting with Vitalik. He's meeting with Joe Lubin. He said in the email that he was going to talk to Vitalik, to learn more information. And let's go put it up one more time, please, on page 135. He's asked, did you have communications with anyone other than the SEC staff about the substance of your remarks in the June 14th, 2018 speech before you gave it? No, not on the substance. What about the Perkins Coie memo, Bill? What about all those meetings, Bill, the 4 to 5 meetings that you admitted to, right? What about all those meetings? They had nothing to do with substance. Bullshit. You said that you had to confirm certain things. You asked questions. You had 7 questions that were given to the Ethereum Foundation. Those 5 meetings, all the Andreessen Horowitz meetings, the safe harbor provision, all of that. The final speech has terms in that memo, and you state under oath that you only spoke to SEC staff about the speech. Okay, that's not how we do business, or how we're supposed to do business. We're supposed to have free markets. This is clear. You've got inside regulators picking the winners and losers based on who rushes to hire a law firm. And that system has got to change. And with that, I know it was a long video, but everybody, I'll see you next week.